Another suggestion put forward by the committee is for the abolition of the plea bargain concept. Do you think that outright banning of that concept is the way to go, or perhaps a reform of the way that we've practiced it in the past?
Before plea bargaining dawned in Nigeria, I had researched that concept, I had written books on it, I had publicly advocated its usefulness. And I've cited several examples in the United States, in England, everywhere. In the United States, for example, less than 8% of cases that are charged go to full trial. The others are resolved by plea bargaining. Why? Because the prosecution so overwhelms the criminal defendant with evidence. And that person would then, why was it possible for James Onodifo to plea bargain in England and he wasn't going to do that in Nigeria? Why was it possible for his charges to be struck out? And now those charges have been revived or have been revived lately by the Court of Appeal. Why was it possible for him to run throughout the entire gamut of the judiciary and be given a clean bill of health? Did that have to do with plea bargaining? The problem is that every system that works everywhere and elsewhere, insane crimes, is bastardized there. Presidentialism is not working in Nigeria. It has nothing to do with the concept. It has something to do with us. Criminal system, justice system is not working. It has nothing to do with criminal. Look, you can name everything that has worked elsewhere. Power works everywhere. Power is not working in Nigeria. It has nothing to do with plea bargaining. And so, before people will just start debating a concept that they really understood, they should sit down and then look at that system or concept critically. Plea bargaining is not the problem. Plea bargaining, indeed, is part of the solution. Plea bargaining is not only prosecute. Plea bargaining was not the reason why the federal government of Nigeria withdrew 400 billion charges against Mohamed Abacha. It wasn't plea bargaining. It wasn't plea bargaining that made the federal government of Nigeria to pardon Alamesea. It wasn't plea bargaining because he had gone through the system. He had been convicted, and yet he was pardoned. So the point I'm making is that plea bargaining is not the problem. The problem is the way we practice it, and indeed in the way we bastardize other beautiful concepts that we can transplant. And in any case, those who are making their recommendations, they are overreaching themselves. Because Nigeria is a federalism, and it is the business of every state in the federation to pass its criminal law, to enact a criminal law. As we speak, Lagos State has inserted plea bargaining into its administration of criminal justice law. It's not just now, it's about 4 or 5 years old now. So we should now be talking about training the practitioners and then making them to know and learn how to use the system effectively.
Now, do you consider that this would also be one of the solutions, that we should have a state court of appeal in every state of the federation to serve as a terminal court on state matters, except in cases of weighty constitutional issues and civil liberties and matters of overriding public interest, which would then go to the Supreme Court? And that when we establish the state high courts, the headship of the state judiciary will then move from the chief judge of the state to the president of the court of appeal that we have created in that state.
That can be a solution. The suggestion they are making, the recommendation, if it stands alone, appears good and reasonable. But now put this side by side with the recommendation that you should have 18 more states. So that takes everything to 54 states. If you're going to have 54 states in Nigeria, and you are going to have 54 judiciaries, so what kind of country are you going to have? In terms of the decisions of those courts, having regard to the requirement for certainty of law and the pronouncements of the court. Even in terms of law reporting, even in terms of, case law being coherent. So what are you going to do? We have Court of Appeal. They are not 54 yet. That are giving decisions against one another. Yes. So what are you going to have? That then means that in Ijebu State that they are talking about, if it ever comes into fruition, then in Abeokuta you have one Court of Appeal. Give you a decision that will be different from decision in Ijebu. People should be serious. And I respect those who are making these recommendations. So everything must be put in that context. And I'm saying that what has been suggested before now, and I made that suggestion as far back as almost 10 years ago, that you need to refederalize the Nigerian judiciary. Let every state have its own Court of Appeal and Supreme Court. But if this will be regarded as unwieldy, let every zone have a judicial structure so that cases, ordinary cases in that zone can be dealt with.
Finally, many people expected that the National Conference would have looked at the issues of the excessive powers of the Chief Justice of Nigeria and the National Judicial Council. Do you agree with those who think that perhaps this is one issue that the National Conference should have dwelt on, especially in the light of what's happening now in Rivers State?
I think that they should have done that because of the Rivers State subsection in the judiciary conundrum. I'm using my words advisedly. It's a conundrum because that crisis is needless. The crisis, and I want to be put on record, is largely due to the undue interference of the NJC. And I will say it the way it is. The NJC is claiming certain powers he does not have. And it is becoming increasingly evident that the NJC is pandering to the whims and caprices of certain individuals, either in the NJC or who are close to the NJC. That ought not to be so. In the appointment of a chief judge of a state, 4 institutions work together. Not in the position of one being subservient to the other. They coordinate to ensure that there is a successful transition. So how can the NJC then lord it over all the other institutions as if it is the sole institution that has untrammeled and unchecked powers to have its way? It is not done. And for me, if you don't want to throw that judiciary into crisis, why do you want to subordinate the exercise of the powers of the NJC, seemingly, to aid one particular individual? Why? More so when there are precedents. In Osun State, there was a precedent. Somebody, a judge serving CJ, was from the customary Court of Appeal before she was made the CJ. So why is the case of Rivers State different? The solution for me is that NJC should invite the Rivers State government. Let them have a discussion. And I make a suggestion that the legal practitioners, well-gallanded legal practitioners who are members of the NJC, who ordinarily do not sit on the issue of appointment of judges, should excuse themselves from such meetings. Let the NJC and the Rivers State government go into a closed-door meeting and resolve this matter. And I tell you, because you see, lawyers take causes in arbitration and all that. This matter are not beyond resolution. You can do a number of things. If there's a fixation on a particular judge, you can elevate him to the Court of Appeal if you love him so much. And then you resolve this matter so that the integrity of the judiciary will be left intact.